Hello, honorable members of the class. So let's go to the Gauteng High Court. But I've already spoken about this particular segment of what happened in the beginning of the morning in Judge Rata's courtroom and how Judge Rata actually shocked me, to be honest with you, where now he was saying, okay, this I've been eating imvutu, but if you don't know what imvutu is, it's those crumbs of biscuits. I don't know. There were some things I just did not grow out of them since growing. I don't know. But yeah, the stuff that you saw on my beard, imvutu. So anyways, I don't know if imvutu. Anyways, let's leave it that way. This clip that I'm going to show you, it is exactly what transpired in the Gauteng High Court, where Advocate Baloyi tried it. He tried it. And I don't know what he was thinking. I think maybe he was trying to also show that he's the boss. It's not Gininda who's the boss. I'm the boss because this is our case. We are the ones that brought you here type of situation. I don't know what that stunt was all about, but it made him look very, very weak and almost petty, to be honest. Even if you see, check his facial expressions. He's almost annoyed, angry, and trying to be assertive type of situation. And Mr. Nisi, which he's the one that actually impressed me the most, when he was like, calm down, there's nothing illegal about what we are doing, you are doing it. Just reminding him that you're being a hypocrite at this point in time. And Bongani Ntanzi also adding salt to the injury of Advocate Baloyi. I was like, sweet, very, very sweet. I must also confess, guys, the way Gininda, number one, he is lying, and number two, confusing himself, number three, and the way he winds down this road and meandering all the way to, you know, who lives there. I fell asleep. I don't know what happened the second round after the short adjournment, because he was just speaking and speaking. And then you're like, but you're not answering the question, sir. You're not answering the question. This guy's winding and going down. Sometimes I feel like Mr. Ramosipili just needs to yank him a little bit and say, sir, answer my question. You are off tangent again. But it is what it is. I feel sorry for everybody that is in that courtroom, because this man is boring, but lying at the same time. It's a strategy, I'm sure. I don't know. And that, guys, let me leave you with this clip and we'll see each other. Hopefully this time around, I'm going to be awake type of situation, because I will be buffet too. It's not right. I hope I don't have imvutu on my beard again, guys. Yo, that was a little bit. I thought that I would have the microphone here throughout, but at some point I switched. Oh, it was this side because I switched the hands. Anyways, guys, please do not leave this video without liking, sharing, commenting, and subscribing. And check out the brilliance of the defense lawyers in this clip. I'm very impressed. And Rata as well impressed me, I don't want to lie. And if you like us, you will click the bell notification so that you get notified every time I upload a new video. And then you come with your two icons together, rub them together, and spark your own opinion, because we are not experts here. We just talk our own opinions and speculations about what you are hearing in that courtroom in the Senzo Mayor deletion trial. See you later. Goodbye.
I just want to sound a warning to my colleagues regarding the use of statements either in this docket 63610 of 2014 or in 3751 of 2019. There's a tendency to quote passages of statements in either of the dockets, but until now, out of this main docket, 63610 of 2014, and invite Brigadier Gininda to comment on what those witnesses are saying. We submit, my lord, that that is improper. You cannot use, as we've objected yesterday when Mr. Ramosipili was quoting passages from some statements and eliciting the comments of Brigadier Gininda. you cannot use inadmissible evidence in cross-examination. The only way, my lord, to use such statements is if the defense signal their intention to call those witnesses. But unless they do that, my lord, that remains hearsay evidence. And in this regard, we just want to briefly refer to the Handbook of Detroit Criminal Procedure under cross-examination on page 22 to 54, when it deals with cross-examination and re-examination of witnesses. He writes the following regarding the use of inadmissible evidence, and he says, cross-examination based on inadmissible evidence is not permitted. And he then lists the categories of such inadmissible evidence, and amongst those categories he refers to an unproven document which the witness also cannot prove. And he quotes then the case of Howard versus Decker, Vetcop and Agencies, and Forwest Estate Pty Ltd and De Sousa, 1971, volume 3, essay 937T at 948E to H. We had a look at that case. It's an old case, 1971 case, and it's the decision of the then Transvaal Provincial Division. It was a civil case, but the principles are still equally applicable. Fossilores Case 3751 of 2019. We don't want to disturb the flow of the proceedings by standing up and objecting every time. Hence, my lord, we just felt that we just need to bring this to the attention of my colleagues. Thank you.
Yes, Mr. Ramsey, please.
As the court pleases, my lord. My lord, I note the submission by my learned colleague, my lord. However, I cannot respond at this stage, my lord, because I did not go and prepare for that. I'm busy preparing for the application. If I need to respond, my lord, it will have to be tomorrow.
I don't understand. Yesterday we said you should prepare.
No.
Both of you. Or no, not you, both, all of you.
No, the court said we can either discuss it amongst ourselves or prepare. Or prepare.
Yeah, that's what I said.
Yes, or prepare, not discuss and prepare.
How do you prepare without discussing?
No, the discussion was whether is it necessary to prepare for this argument pending that I'm going to use the statements or not. But once we decided that I'm not going to pursue that line of questioning using those photos, we then decided amongst ourselves that preparation is no longer necessary.
I see.
Yes.
So you're saying, I don't want to prejudice your client. Did you want to use that information? Let's start there.
It is not material for my cross-examination.
Well, now, why did you bring it to court and...
My lord, I specifically stated why I brought that information to court.
Oh, okay, fine. What was the reason, by the way?
My lord will recall, I don't know which witness was it during the main trial. Reference was kept on mention of the park, the left, 200 meters. Yes. And the court asked my learned colleague, Mr. Baloyi, that it's imperative that the court has sight of the photos of the park and the surroundings. And in light thereof, my lord, I think the following day, Mr. Baloyi came and finished all of us with disclosure regarding those photos and the album and the statement of the person that took those photos. However, my lord, that was not pursued thereafter, and the court never inquired further. But then as I was preparing, my lord, like I said, I came across those photos, and it was just to remind the court that the court once asked for these photos. Is it also necessary now to have that witness come and testify to orientate the court as to the park that was searched by the community, by the first responders, where it is alleged that the intruders ran, which is 200 meters away from the scene? That was the purpose, man.
Yeah, it's obvious the court wanted to know if there were photographs of the scene. And the answer then, because it was silent, I thought no photos were taken.
It is unfortunate, but because we were furnished, my lord, with the photos the following day, after the court.
And you never brought that to the attention of...
It was never brought to the attention of the court.
Now the question is, do you want to use them, sir?
No, I'm not going to utilize them, my lord.
Because I don't want it to be said that you are being refused, and your client is being refused an opportunity to use those photos, which were supposed to be part of his defense.
Yes.
Are you with me?
I am, my lord.
Yeah.
And I did discuss it with him this morning to say I'm not going to utilize the photos because this was the context within which I was bringing it to the attention of the court, and he is well versed, my lord, that I'm not going to use those photos anymore.
Let's hear your colleagues, Mr. Nisi.
Thank you, my lord. The prescription, which is of a blanket nature, my lord, that the state seeks to impose on the defense with regard to the usage of certain statements, tends to be unlawful, and from where I'm studying, it's a bit rational, because it does not take into account the provisions of the Law of Evidence Amendment Act number 45 of 1988, which amongst others stipulates that information that is contained in a document or information that is contained in a statement may be admitted on a provisional basis, where the person who seeks to use that information undertakes to call the person whose property value the content of such statement lies. So the person who wants to use that statement can simply make an application to court and say, my lord, may I please be granted the leave to use the content of the statement, because later on then I will call the person upon the credibility, upon whose credibility the content of this document lies. There's nothing wrong with that, my lord. That is just point number one. Point number two, my lord, is the state makes a disclosure. Upon investigation, or let me actually start it here. The state receives a complaint that is investigated by police. The police go out and take statements from certain witnesses. Then the matter gets brought to court, and there's a trial such as this one. And the state makes a disclosure. In the process, circumstances had arisen in these courts, and in certain circumstances may also arise. I've also done this as well. Then you go to the list of state witnesses. Amongst the list of state witnesses is a particular Mr. X, maybe he's witness number 5. And then they call the first witness. The state called his first witness. And then the process of cross-examining that witness, who's witness number 1. And then you refer to the statement of witness number 5, who's also mentioned in the list of state witnesses. For instance, you come and say, Mr. Witness of Brigadier Keninda, the state is going to call Mr. X, who's witness number 5, who's going to say, amongst others, this and 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 this. I'm not even so sure, my lord, whether that is unlawful, because the person that has been referred to, who the defense believes that later on will be called by the state, is amongst the list of state witnesses. So there's perfectly nothing wrong with that, my lord. unless if the state from the beginning indicates that these are the specific names of witnesses that we are going to utilize in this trial, the rest we will not be utilizing. It is therefore upon those bases then we can approach the court and say, on the basis of the fact that the state is saying that they will not be utilizing this witness, may I then be granted leave to provisionally use the statement, because most probably this information is very important for the defense of the accused person. I may call these witnesses in our defense, and then the court provisionally then allows the usage or the content, the usage of the content of such a statement, my lord. But a blanket prescription that such documents cannot be used, my lord, I think it's unlawful and it has to be rational. What should actually happen is it should be a case-by-case determination, my lord. It should not be a blanket amnesty. I therefore do not align myself with the suggestion or with the application by my. I don't know whether it was an application, but I heard him saying that he was sounding a word of advice. I don't align myself with that advice, my lord. I may say from the bar that I'm not inclined to accept that advice. Thank you, my lord.
Okay. Yes, Mr. Ngumalo.
As the court pleases, my lord, before Mr. Ngumalo addresses the court, I was called by my client to indicate that, my lord, the application or submissions by my learned colleague, my lord, are one-sided.
What?
Are one-sided because, my lord, he tells me that Brigadier Gininda has referred to the statement of Absalom Zungu, which he says links accused number 1 and 2. Yet that Absalom Zungu, the state did not call, and they led evidence to that effect. The evidence of Magaleni, who's the deceased, who describes suspect B, which the state alleges is accused number 2. Also, that person was never called. We have not been furnished with the death certificate of that person. So what he essentially says is that the state may be making this application, but what is good for the gender is the warning that he sounds to us, he must also sound it to himself. As the court pleases.
Yes, sir. Mr. Ngumalo.
My lord, the use of hearsay evidence is governed by Section 3 of the Law Amendment Act 45 of 1988.
Is that true?
Sorry?
Is it true or correct to make that statement? That hearsay evidence is governed by the Evidence Act, Section 3 of Acts, the 45 of 1988.
There are various, I think there's about 7 requirements that must be met before one can.
Yeah, that's why I'm asking, is it correct to say hearsay evidence in this case? Because according to what I understood from Mr. Baloyi, those witnesses are alive. In terms of the Criminal Procedure Act, they must either be dead or missing.
Yes.
So that the court can find that in that instance, that evidence could be admissible in the interest of justice. But that's why I asked Mr. Ramsipiri yesterday, this gentleman who compiled the photographs, where is he? He's still alive. And he never answered me. Just said, oh, well, you know, I don't know. So I couldn't make a ruling then. Okay, go on.
No, I was also going to address the court on the basis that if the court is forewarned that the credibility of that evidence upon whose property value relies is going to be called, then that evidence may be provisionally admitted pending the calling of that witness. And in the event that witness is not called later, then that piece of evidence may be removed from the record.
Fine.
That's how I understood it. Yeah. So if the court in any proceeding, for instance in this case, is warned that the counsel is going to use an affidavit and this person is going to be called, then the witness may be cross-examined on the basis of the content of that affidavit. If the court is forewarned, then failure of the counsel in calling that witness that was referred to earlier, then that evidence is scrapped from the
Okay,
record.
fine.
That's how I understand the whole
Okay.
procedure. Thank you.
Yes, Mr. Mshola.
My Lord, yesterday when we adjourned, the court granted us the indulgence to discuss with the state regarding the status of the content of the docket 375. My Lord, we did discuss the status of that docket, and the state indicated to us that since it was discovered by the state to us and we are in possession of that information, it can be used by the defense. Secondly, my Lord, it is the duty of each and every counsel who is intending to lead evidence on a particular statement, if the author or the deponent of that statement is no longer alive, to inform the court and bring the necessary application in order to be able to use such statement when cross-examining, especially this witness who is the investigating officer in this court. As a result, my Lord, my submission is that since we have been given that permission to proceed, as the time when comes when the counsel intends to lead evidence on a certain particular statement, each counsel knows the procedure, my Lord. That's my submission.
Yeah, but I thought here we're speaking about photographs, documentary evidence. Is that not so?
Yes, my Lord. My Lord, the photographs, unfortunately, my learned friend has decided not to proceed with that. However, the state had indicated that if he wants to lead the evidence regarding that statement, he can still proceed, my Lord. And we also asked the state to make those witnesses available to us if the state is not intending to call them. And the state indicated that as soon as we indicate, the witnesses will be made available to us. Yes. Therefore, whenever counsel is or intends to lead that photo album, especially in my case, I will be calling that witness who took that photo album, and I will be using that photo album.
Is he alive?
He is alive, my Lord.
Where is he?
Mr. Kininda can get
it.
No, my Lord, the investigating officer will be approached when we are about to lead that information to get the whereabouts of the witness for us. Because once the state has finished with its state case, he will make those witnesses available to the defense, and the investigating officer will get them for the defense. And then we'll be able to call them, all of them, my Lord. We are going to give them a list of all the witnesses that the defense intends to call.
Okay, fine, no problem. Yeah, as a general proposition, this court is obliged. I've listened to the defense and even the prosecution. The government of this debate is the fact that Mr. Ramsipidi wanted to utilize photographs which apparently are the result of an investigation by the state in another case. And I think Mr. Baloyi initially objected that, but after some time relented to say if Mr. Ramsipidi wants to use that evidence, which is documentary evidence, he may deal with it as he wants. Am I quoting him correctly?
That's correct.
Right. Now, as we all know, the Constitution is the premier law in our country. What Mr. Baloyi stated about hearsay evidence is correct, legally, no problem. And also what Mr. Mnisi states about Section 3 of Act 45 of 1988, the Evidence Act, which came into being 1961. I'm sure all of us were born. It's correct. But there is a rider here. I asked, how was this evidence acquired by Mr. Ramosipidi? And Ramosipidi said it was apparently discovered by the state before this matter was nullified. Is that not so?
No, it was during this matter, the current matter, not before Justice Maumela. It was in this trial.
Oh, I see.
Yes.
Is that so, Mr.?
Well, and I don't want to cast aspersions on anyone. The main disclosure regarding 375 was done during the trial before Judge Maumela.
Yes, I think I listened.
Disclosing anything.
That's it.
Pertaining to the and as I say, Malot,
No, fine.
Memory can sometimes leave us in the lurch.
Yes, I listened to say this was discovered during.
Yes, but
I even said my predecessors.
Yes, that is my recollection.
Yeah, quite. But it was not formally discovered at the beginning of this trial on the 17th of July, 2023.
No, 375.
Yeah, 375. I'm talking about 375.
Yes, was discovered during the proceedings that were aborted before Judge Maumela.
Yes, that's how I understood it. You don't agree, Mr.?
No, I don't agree, my lord.
You were all in court. I wasn't here.
My lord, how can that be?
I was sweeping the floors when you were sitting with my brother Maumela. I wasn't there.
But my lord,
and you can agree
yes.
on this. You were there during Maumela's time. You were there, or you are here during my time.
But the essence of my submission was that the question emanated from your lordship, not Justice Maumela.
Okay. Otherwise we'll waste the whole time. Yeah, okay, let me just settle it. In terms of our law, the Constitution, about Section 35, 1C of the criminal process of the Constitution states that an accused person has the right to defend himself and to challenge the state's case also. Consequently, accused before court here, they have the right to challenge any piece of evidence. Like, for instance, because it has been discovered, this court doesn't have to inquire as to how it was discovered, because it appears that in any event, Mr. Ramosepili wanted to utilize this evidence of photographs or an album. And I don't want this case, wherever it goes, they say this judge never dealt with this exigence. So I'm dealing with it now. When you decide not to use it, it mustn't be said that I refused you the opportunity to use it. Okay? Because my finding, as I say, is that your client has the right to defend himself. And then in section 151(2)(a), at common law also, there has always been a right vested in an accused to call witnesses on his or her behalf. And that the Constitution recognizes this right in section 35, and also the Constitution now guarantees every accused person, as part of the right to a fair trial, to the right to adduce and challenge evidence. And this principle was reiterated in the case of S versus Duma. It's an unreported KZP case number AR 141/14. Where it was reported that it is an irregularity if a judge or a court denies an appellant or an accused person an opportunity to call a witness in defense of so fundamental a right that if that happens, it vitiates the proceedings in the sense that he has been deprived of a fair trial right. And this applies to all the evidence, documentary or even evidence relating to videos, photographs, and verbal recordings, all evidence. And this was also repeated in the case of Ugwebu versus the National Director of Public Prosecutions, case number 86184/201, which judgment was delivered by my late brother, Classens, on the 28th of May, 2019. And at page 22, he says the court recognizes the right, and that this right is underpinned by a right to a fair trial, and entails that all available evidence, including evidence that would assist an accused in his or her defense, should be made available, all, irrespective of how that evidence was acquired or discovered. In S versus Maluleke, unreported case number CA and R 34/2013, which was finalized on the 1st of November 2013. The court at paragraph 60 confirmed that where the defense fails to call a witness whom he or she could have been called, it is open to the defense to request the state to make that witness available. And actually, to put it in its proper context, the state is obliged, if it doesn't utilize any witness or any document which pertains to a case in which the right to adduce evidence or the right to defend the state's case, that is by the litigant, the state is obliged to make that evidence available, whether it be, as I say, documentary, photographic, or through video material. So it's a legal question also that if the state is not in a position to call any witness, it is incumbent on the defense to do so if it so desires, in order to actualize the right to a fair trial and to adduce and defend evidence in terms of section 35(1)(c). This case is peculiar in the sense that this court finds that this evidence, which is apparently wanted to be used by Mr. Ramosepili, which pertains to documentary evidence of photographs which were allegedly acquired or taken in another case, it doesn't stop Mr. Ramosepili or any accused person to utilize that evidence, because the right to section 35(1)(c), in my view, it's more decisive than the right to the privilege which is supposed to be extended to any evidential material which is in the possession of the state. Because we must bear in mind that this evidence, we keep saying it's a case. It's not yet a case. 735, it's not a case. It's still an investigation. A case only commences when there's litis contestatio, meaning that it only commences after the state has placed or put a charge to an accused person and that accused person pleads. Only then does that evidence become evidence in the accepted weight? Otherwise, still an investigation. So Mr. Ramsipiti actually wants to use photographs which are pertaining to an investigation in another case. But I'm saying the right of his client to Section 3551C supersedes even the privilege which the state could claim or wants to claim. Okay. So if you want to use that evidence, you may do so.